you doing?
All right, let's call her to order and call the roll.
All right, Senator Hanger. Oh, sorry, Marianne, are you ready? Marianne, are you good?
Yes, sir.
Okay. Senator Stanley. Senator Favola.
Here.
Senator DeStaff.
Here.
Senator Donovan.
I'm here.
Senator Chase.
Here.
Senator McPike.
Here.
Senator Howe.
Here.
Senator Spruill.
Here.
Senator Morrissey.
Here.
Senator Pillion.
Here.
Senator Bell.
Here.
Senator Hashmi.
Here.
Senator Kiggins.
Here.
And Senator Lewis.
Here.
Mr. Chair, you have a quorum.
All right, folks, we've got one bill in front of us. That is Delegate McQuinn's House Bill 5030. Delegate McQuinn, you are the star of the show. So
That's scary. Thank you, Mr. Chairman, and thank you, committee. I appreciate it. Opportunity to just talk about the bill a little bit. It is my understanding there's been a lot of conversation going on about it. But anyway, so House Bill 5030, that, and I know we had in prior session, we had a lot of discussion about this issue of monuments and statues. But what I found out that there's been a lot, I guess, in terms of significant interest in this, but there's also been many attempts for people to go take it into their own hands as it relates to addressing the statues. We all know why the statues are up and why they've been put up, some of them 130 years ago. And basically, it has been about racial intimidation. They've been racist. They have been just for a limited number of individuals in our Commonwealth and across this country. And they've been very, very offensive. And so one of the things that I thought that House Bill 5030 could do was to help to address the process. In other words, giving localities the opportunity to address it, but giving them more flexibility. I felt that the House bill that we passed in this last session certainly put a lot of stipulations in the bill, and it was my intent to look at it and see how we can make changes once again to give more flexibility to localities. It changes the wording, contextualize a cover to the word alter, and it gives authority to the localities to establish the process for removing or relocating these monuments. And so it's not a one-size-fit-all process with us governing from afar. They can have the discussions within their localities in terms of how they want to address statues or monuments that have been placed and put in place. And so this is, again, it just gives, again, the authority to them. The localities will be the entity impacted by the decisions the most. And so, and they will be the governmental body who will be responsible for everything, the fiscal impact, and making the process transparent and working for them. The other piece, it removes the exemption of the property of a public institution of higher education within the city of Lexington. Even though I got phone calls, of people who were in support, phone calls and emails were also coming in a monumental way, where people say, listen, we've got to figure out how we move this forward and how to make more flexible for the localities to address it. As we know, someone was hurt in the Tidewater area, and one of my greatest fear has been with individuals going out themselves and trying to dismantle or pull these statues down. These barriers are in the way, and how do we give, again, opportunities even for localities that they have to say within 1 week we need to have this discussion. They tell their citizens, we're going to have this discussion, and let's move forward to address it rather than people being able to do these things themselves. And I think basically it's just looking at the systemic racism, the inequities and inequalities again, and what these statutes, how they have impacted a large population of our Commonwealth. And the thought that there was a prohibition many years ago to not do anything to remove these statutes says volumes to what they were thinking back then about generations that would come. And so I just think we have an opportunity, and I'm asking that you all would, pass House Bill 5030, once again, giving more flexibility. Thank you, Mr. Chairman.
Delegate McQuinn, are there questions for Delegate McQuinn?
Mr. Chairman,
Senator Favola.
I did have conversations with Delegate McQuinn and of course, other members, mainly members of our Senate committee. I do have an amendment in the nature of a substitute. I don't know when you want to hear that or if you want to take speakers first.
No, let's go ahead and get in front of us.
Okay. All right. First, let me say that Delegate McQuinn, I completely appreciate the intent of your bill and where you want to go with it. And I know that in the conversations we had, your interest is really enabling local governments to keep their communities safe when emotions are high, and we have folks who really do want these monuments taken down. My amendment does restore the requirement for a public hearing. So it puts back paragraph B, but it does allow in lines 40 through 43, it does give a locality the authority to remove, relocate, or alter any monument for the veterans of the engagement of the Civil War without initiating the public hearing requirement if the jurisdiction is acting expeditiously to prevent harm to any person or property as a result of an imminent emergency situation. So I think that gives the carve out that jurisdictions could use, but it still protects the I think the obligation that local governments have always adhered to, which is having a public process when they're moving property located on public buildings. So,
Yeah, the substitute. It hasn't posted yet.
Mr. Chairman, I would move the adoption of my substitute.
Is that
Mr. Chairman, Joe.
Senator Morrissey?
Thank you, Mr. Chairman. We're trying to get the substitute in front of us right now, and we can't do that. Or actually, my LA can't do that. Is it been posted?
Mr. Chair, I believe it's been posted. I've just sent it through on BDS, so it should have come through. You might even have to just refresh the browser, but this is my first time using the electronic send. So if I need to send it again or do something different, I'll do that.
Mr. Chairman, maybe if we can just pause for 30 seconds so that
Sure.
the members can get it.
Yeah, why don't everybody try and press the refresh button and see. I've got it written down here.
It's finally loaded.
Senator McPike said it's up.
So
Senator
you
Morrissey.
got to press the refresh button. You're getting it.
I will just say the guts of the substitute are on lines 40 through 43, so you don't have a lot to read.
And Senator McPike says it's up.
Mr. Chairman, wanted to second the motion and speaking to that motion.
Sure. Go ahead, Senator Bell.
Yeah, I appreciate Delegate McQuinn's efforts on this bill. We've spoken about it, and with Senator Favola, I think public hearings and transparency are very important, and I appreciate her willingness to work on this. So I'm happy to second that motion.
Let me let Senator Morrissey get back in front of his computer so he can look at it. Does anybody else have any questions in the meantime of either Delegate McQuinn or Delegate Favola or Senator Favola? No questions?
Mr. Chairman,
Yep, Senator McPike.
I guess just one question. The substitute, I guess the original bill, I would not see a conflict with the pending court litigation. However, with the substitute as narrowly drawn, it actually puts it kind of squarely in the crosshairs of pending litigation.
Which is something we typically don't do. Right.
I guess
Right.
I would,
That's my concern. I understand where she's going with it, but now with the change and the carve out, it almost fits directly within the pending court case. Maybe
would ask-
counsel can speak
I
to
would
it.
ask general counsel to respond.
Yeah, Dave or Jeff, do you have any thoughts on that?
Not at the moment. To be honest, I haven't had a ton of time with this substitute, but
What you been doing?
and I am unaware of where we're at actually with the litigation. I don't know if Jeff has thoughts.
Yeah, I have not seen, the filing, the court filings and the litigation, so I can't really, I'm not sure I can really weigh in.
Well, are there, and do you even know this, Jeff, are there two suits? Or have they been consolidated? What's the status? We didn't even know that.
I'm only aware of one at this point. I believe one was dismissed or withdrawn.
Mr. Chairman,
Senator Sproul.
I'd like to, Senator Pike would share what part that is in conflict that with the litigation, either what changes need to be made to make sure there won't be in conflict. If he would share that with us, I would appreciate it because I'd like to know myself, what was he talking about? What part is it that would be in conflict? And then if so, how can we change it so it wouldn't be in conflict? He would share with that.
Mr. Chairman, I'm not sure I can provide legal opinions as I'm not counsel, but it's my understanding there's pending litigation in Richmond. I was there with the removal of the Jackson statute and witnessed, in fact, which I think is a positive move. However, there is pending litigation in terms of whether or not the law we passed 6 months ago was followed in terms of the process. And it's my understanding Richmond had utilized sort of an emergency declaration in order to remove it, and maybe other members of the committee that represent the Richmond area can chime in, but that's sort of my basic understanding. And so the substitute sort of even more narrowly draws it right into the crosshairs of pending litigation. Maybe
Mr.
Senator
Chair.
Morsi or you or Hashmi can also chime in.
Mr. Chairman, I have a question for council. If this bill is to pass during special session, it would not go into effect immediately, of course. And so would it then have any effect on the litigation that is currently pending in Richmond?
You know, it's hard to say how long the litigation is going to take, Mr. Chair. So I don't think that my understanding is that assuming this doesn't have an emergency clause, that it'll go into effect January 1st, I believe. I think it's a 3-month delay. But I don't think that a court will be necessarily looking at this in the meantime. But it is longstanding practice not to interfere with ongoing litigation.
Any other questions of either Delegate McQuinn or Senator Favola? All right. Let me make, I'm sorry, go ahead.
I have no idea if it's because basically I'm just seeing it as well. But I did have conversation with Senator Favola and thought that if we feel like we needed to mandate that the public basically would be involved, then how would we go about that and addressing the present day situation? And that is where people are stepping out on their own and doing something, and we in local government hands are tied in many ways. So in terms of how with the lawsuit, the case, I just don't know how they interact. And
well, and I think Delegate McQuinn, I think to that point, I think that's what we all fear. And that's part of the problem with trying to do this stuff in a special session in general, but in a special session sort of circumscribed or by a pandemic, which prevents us from having the interactions that we typically would have as freely as we typically would have on these issues. And so, I mean, I think Senator McPike's point, ever since I've been here in 2004, I mean, that's always been the sort of unofficial rule, I guess, and maybe it's official somewhere, I don't know, that we don't do anything that may be seen as interfering with ongoing litigation.
Mr. Chairman,
Senator Sproul.
since my Pike is not a lawyer, then he cannot say this interfere with the present day location. I gave him the opportunity to tell me that he has a law degree, but he didn't do that. So since he didn't do that, then who says that it is interfering when this will not go into effect immediately anyway? So why can't we pass the substitute and wait and see?
Well, and we can, but
Mr. Chairman.
Well, just a sec. To your point, as a lawyer, I can tell you that from now till January, in any type of litigation, particularly high-profile, complex litigation, is but a nanosecond. So it may not be resolved till the following January, for all we know. And Dave and Jeff, while we have legislative services here, I mean, these guys can only be expected to opine so much on the fly. And I respect what they do for us is fantastic. So for them to actually say yay or nay on a question like that is probably a little problematic either way. So it's just a question, Senator Sproul, that Senator McPike has put out there for all of us to consider as we consider the substitute. And I think Senator McPike had something he wanted to say. No.
Mr. Chairman?
Senator Howe.
I don't see anything wrong with the original bill. And it doesn't have the problem we're currently discussing. And I'm wondering if Delegate McQuinn likes this substitute, would prefer this substitute to her original bill, or where she stands on it.
I mean, the original bill would have been my preference because, and this is what my knowledge, and again, I mean, I don't know, there have been some who's been a part of local government. When they're, you know, I just don't expect local government to say we're going to do nothing to engage the public. I mean, that's not how local government operates. They are often engaging, and so you've got a group of 5, 9 individuals sitting around who represents a constituency. They want to hear from their constituency and want them to help direct them. And so you know, the way the bill was, the original bill is written, even though it says local government giving them the authority, well, the authority really comes from basically their constituency. And so when but I just felt that we have put something in place that tied their hands, that creates a barrier for them to move in a more, you know, I guess, aggressive, well, not aggressive manner, but to move forward before others, some of their constituents, decide that they're going to take it down themselves. And again, it's a public safety issue. And that's why the lawsuit, even with the city right now, that the mayor felt that someone is going to get hurt. And so, you know, how do we make it more flexible for them to be able to move forward and accomplish with whatever they're trying to accomplish?
All right, folks, we've got a substitute in front of us. It's been seconded. Why don't we figure out what we're going to do with that, and then we'll go on to talk about whatever's left, the substitute or the unarmed.
Mr. Chairman?
Senator Morrison.
Just 2 things. One, in fact, you asked earlier the status. Dolores, the case is set for trial right now on October 19th, this year, of course. And it was on August 25th that Judge Marchant, who took over for Judge Cavedo because he had a conflict. Folks outside of Richmond, he lived within the area, therefore he recused himself. The last thing that Judge Marchant did was dismiss the efforts by the Attorney General to dismiss the case. So it's right now, we got a trial date for October 19th. That's just the fact. But what I'd like to know from Delegate McQuinn is we usually give the delegates the courtesy of asking them, Mr. Chairman, do they like the substitute or not? I realize it's our vote, but I would like to hear a thumbs up or thumbs down from Delegate McQuinn whether she likes the substitute by Delegate Favola.
Senator Favola.
Excuse me, I beg your pardon.
Delegate McQuinn?
My preference is the original bill, House Bill 53, the original, as it is, the language is written. That's my preference. But however, in talking to Senator Favola, she was having some challenges with it. And so I wanted the bill to pass again, with the understanding that there are some variables that I believe are that we could address and help these localities. And I know Senator Marcy is not up or down, but I know my preference is the bill as
original.
written. Yes.
May I, Mr. Chairman, may I just give the rationale for my substitute?
Yes, go ahead.
Okay. The original bill, and again, I could have done something differently and I apologize, but Part A, of course, includes all monuments. So not just Civil War monuments, but, you know, French and Indian War, World War I, World War II. So all the monuments are sort of thrown in there. And then it just completely removes the requirement to have a public hearing for any of those, for moving any of those monuments. So that's sort of a very wide net. And although I understand that local officials are elected by their constituents, and it would be very foolish to not have a public hearing if you were going to move a monument. This, in effect, though, is a very broad net. All the monuments, not just Civil War, no requirement for a public hearing. And I actually do think I was not comfortable completely removing the requirement for a public hearing. I just was not. And there's also language in here that in the original bill, the governing body has to offer the monument to, you know, an historical society, a battlefield, or a government. And I think that just makes some sense. Now, maybe the local government will do that anyways without, you know, the mandate, but I thought that made some sense. So I was just trying to carve out something that really addressed the sort of current situation. And get in the fact that if there is a danger, local government should be able to act to protect its folks. So that's where I went.
Senator Favola, I think that the part that you're talking about offering it, I think that part remains in the bill. I think I am.
Mine has it.
Okay. All right. Okay.
It's stricken out.
I didn't remember.
I mean, I wish we had a little bit more time to talk about this, but I have been informed that in a special session, you really can't carry bills over. So.
All
Mr.
right,
Chairman, one question.
Yes, sir.
What bothered me is the first part, and that we said all monuments. If Delegate McQuinn is really concerned about the Confederates monument, then why can't we say that? Because Senator Viola said that the other monuments, we don't want to include all the rest of them. So why can't we just that one part make it specific that we're talking about the Confederate monuments?
Well,
and that way it would free up all the rest of them. That we're not talking about all of them. We're going up what we're talking about. Is that a possibility?
Right now, we've got that substitute in front of us, so we need to take a vote on that. And if we want to drop back and toy with it some more, we can do that. So let's go ahead and call the roll on the substitute. Adoption of the substitute. I think we need a roll call on that.
All right, Senator Hanger.
Aye.
Senator Stanley. Senator Favola.
Aye.
Senator DeStaff. Senator Donovan.
Sorry, I'm here. No.
Senator Chase,
No.
Senator McPike,
No.
Senator Howe,
No.
Senator Sproul,
Aye.
Senator Morrissey,
No.
Senator Pillion,
No.
Senator Bell,
Aye.
Senator Hashmi,
Aye.
Senator Kiggins,
No.
Senator Lewis.
No.
5 ayes, 8 nays.
Okay, so we're
I
back.
was a no as well. Sorry.
Oh, well, Senator D-Step was a
Okay.
no.
5
Sorry
ayes,
about that.
9 nays.
All right, so we have the original bill in front of us. Are there any questions as to Delegate McQuinn on the original bill?
Yes, Mr. Chairman Sproul, again.
Senator Sproul.
Then I'm trying to figure out just that Part A that Senator Bobola was talking about, Part A, to make it specific what we're talking about. We're talking about Confederate monuments, and the way it's written, it's all monuments. Am I right about that, someone?
A at the bottom.
Am I right about that? Could someone explain to me? I'm just trying to distinguish. We're talking about all monuments, as the bill saying. We're talking about Confederate monuments. I want to make it, can we amend to just talking about Confederate monuments? That's what I'm trying to get out there.
That's a question for legislative purposes.
I can't hear you, someone.
Mr. Chairman.
Senator McPike.
Yeah, to, I guess, respond to Senator Sproul's question, as the bill is presented, it applies to all monuments.
Okay.
And council can certainly correct that, but that's my reading of it.
Yeah.
Okay.
It applies, so there'd be no public hearing requirement.
But I'm not touching that part. I'm just concerned about the A right now, Mr. Chairman. So I'm trying to figure out what can we do, Mr. Chairman, right now, a substitute to just make it Confederate monuments instead of all monuments.
I mean, somebody can offer an amendment to that, but I mean, we'd have to
I mean,
have,
Mr. Chairman, that essentially was my substitute.
right.
That was my substitute. It just removes the public hearing for Civil
No,
War.
I'm not talking about. I'm not saying the public hearing. No, I'm not talking about that. I'm talking about as far as the A that you're talking about is saying for all monuments. I'm trying to get rid of the word all monuments and just Confederate monuments. Forget about the public hearing part of it. Just the part saying instead of all monuments, we're talking about Confederate monuments. Let everything else stay as it is in her bill.
Mr. Chairman, since we're
I'm sorry, Senator McPike, go ahead.
Since we're talking about public hearings, I know that as a big part of it, I know there's probably some speakers as well. Maybe the committee could hear those and then
No, I want to get my substitute first, Mr. Chairman, but I want to have substitute just to remove the part all monuments and put Confederate monuments. And everything else in her bill stay the same.
Dave?
Yes. So Senator Sproul, the crux of the section is what we're doing with those monuments, and it already includes all of them as it exists. It's just we've added all of those other conflicts and wars over time. So if we were to sort of separate out Confederate monuments, that is, as Senator Favola said, roughly what the substitute that was just voted down did. It created different rules for Confederate monuments. So I think the section A really only makes sense in the context of the following sections, which is that that things can be done with those monuments. What can be done, whether you need to have a public hearing or whether you need to offer it to a battlefield, for instance. So just separating out Confederate monuments, it basically is what that substitute did.
Okay, thank you.
All right, so we have the original bill in front of us. Let me just, and we do have some folks who have signed up. We've got about 6, 7, 8 people who have signed up and want to be heard. But let me just make some general observations here about some things that concern me. My concerns are largely process concerns. And I've talked to Delegate McQuinn about this a little bit. I know what she's trying to do. I know what her city has gone through and continues to go through. Of course, I'm fairly close in proximity, reasonably close in proximity to Portsmouth, and saw what happened there. But the first question I have, and this is actually a real question for Legislative Services, is part of my process concerns. Dave, what does the call to the special session provide for?
So what I think you're referring to is the procedural resolution that was adopted, and it stated what bills or topics we could pass
Right.
bills on. I can read it for you. It involves 1, police reform, bills related to police reform and criminal and social justice reforms. 2, impacts on health, education, state and local government operations, business and the Commonwealth's economy from the coronavirus, COVID-19. 3, budget bills. 4, single house commending or memorial resolutions. 5, the rules of procedure or schedule of business for the General Assembly in either of its houses or committees. Or 6, appointments subject to confirmation by the General Assembly or either house.
Right.
Mr. Chairman,
Senator Favola.
the Senate didn't adopt a procedural resolution. That was the governor's call.
Right.
So the Senate did not adopt a procedural resolution, which is making this a more complicated conversation.
Yeah.
Okay. I can read the governor's order as well if that's helpful or not.
We don't follow the governor, we follow the Senate.
But the point I'm trying to make is obviously, I think everybody had a general understanding of what we were gathering for, which is expanded, which is why we're here well into, or will be here well into October, because we vastly exceeded, I think, some of the subject areas that we wanted to cover. The second problem I have from a process standpoint is everybody on this committee recalls we went through the tortures of the damned during the regular legislative session when everybody had a chance to speak on a House bill and a Senate bill. And then then it went through that process. There were floor amendments. Then it went through the conference committee. And it came out in a different format after the conference committee. And I voted for it after the conference committee, although I liked the original bill that went into conference, but I voted for it, as did others who had similar reservations, but recognized the overall theme of the bill and the need for it. And so now we come back on the bill came into effect July 1, and here we are back in August and September trying to rewrite it in a special session, which is even more limited in time and consideration in public input because of this virus problem that we have. So I understand what Delegate McQuinn's doing, and I understand there was one extreme incident in Portsmouth where somebody got hurt, and there have been other incidents centered around monuments and iconic figures. But extreme situations often make bad law, and we're back to the original bill. And the original bill does not provide for a public hearing, nor does it provide for an outlet for these things to go into a museum or some other place. That's my overarching concern with the bill. So they're my observations. If anybody else has anything to say, and I don't think, and one other thing I do want to ask, and this is another question for Legislative Services, is there anywhere in code where we allow a locality to dispose of property or anything without a public hearing?
Yeah, so Mr. Chairman, if you're referring to real property, the answer is not really, or no, other than I think economic development authorities can do that, and there are some sort of easements and things that can be expedited. But as far as real property, not really. In terms of tangible property, which is, I believe, what the monuments would fall under, yes, local governments can at least, hold auctions or get rid of a tangible property, I believe, as they need to. So it's kind of weird just because these are sort of half real estate or real property and half tangible property. And it's sort of a funny distinction.
All right. Anybody else before we take public comment?
Yes, Mr. Chairman.
Ben,
my question, in order to, what I'm trying to do is that, what can we do? What kind of amendment can we do to get before the full committee when you got more lawyers and more time that we can think about it. So right now, this is just the committee. But what can we do to get it on the floor when we leave here? We have more time to think about it, and maybe some more substitutes, some ideas can be changed. So I don't want to kill it here. I want to get it, at least if we can get it to the full committee, that where it could be more ideas, more input, and maybe some change that can be made that we can make it workable.
Mr. Chairman.
Mr. Chairman.
Senator Favola.
While you're taking public comment, maybe with your permission, we can ask staff to rework the lines 40 through 42. If there's a way in my substitute, if there's a way it can be worded that does not necessarily bring it in conflict with the lawsuit, I think that's one of the rubs, is why people are having a problem voting for this. Maybe not, maybe I'm wrong. But I would like staff to take another crack at rewording lines 40 through 42.
And Mr. Chairman, yeah, Mr. Chairman, I just wanted to respond and a little bit to some things that you were saying. And I mean, you in terms of some of the challenges that you're having with this, but I probably would not even give this bill this issue any more consideration if what has happened did not happen. I mean, we know that the world has changed since we left. Unbelievably, there's been the transformation of what is going on across the country. COVID-19, George Floyd was killed and died under someone's knee. And so it's been a major change. And so this bill, once again, I want you to understand in terms of how we are trying to address it based on what has changed in the world, what has changed in the Commonwealth. Of all places, we are in our Commonwealth, someone, and I don't know the situation with the young man now, but someone got hurt it was in grave condition. And because the public took it upon themselves with the understanding that, and I've heard it, that we are not moving like we should to help address these issues. And so the effort here, again, and just here in Richmond, and I guess Richmond has been sort of the epicenter of the public being involved in trying to remove statues themselves. I just think that if there's some other, again, flexibility that we can give to localities, and I keep repeating that I just think it's important to do it. Thank you, Mr. Chairman.
Understand. All right, we're going to start taking public comment. All right, and look, I'm going to ask each of you who have signed up here. We're not relitigating the underlying concept of shifting authority to locality. That's done. We're just talking about the provisions of this bill, of Delegate McQuinn's new bill. And I'm going to ask you, since we had extensive testimony on many of these issues during the regular session, to confine yourselves to what is the gravamen or the crux of our bill, and keep your comments as brief as possible. All right. The first one we have up is Kelly Harris Braxton with Virginia First Cities.
Good afternoon, Mr. Chairman and members of the committee. I'm Kelly Harris Braxton. I'm the Executive Director of Virginia First Cities Coalition, and I'm here to express Virginia First Cities support for House Bill 5030, Delegate McQuinn's Monuments Bill. Our members have opined that they support making their own unique decisions at a local level and appreciate added flexibility to act expeditiously to prevent harm. Further, our city council members are closest to the citizenry and are capable of dealing with the consequences of decisions made locally. I thank you for your time.
Thank you, and thank you for keeping your comments confined. Scott Warner. Mr. Warner. There you are. You're unmuted.
All righty, thank you. I'm speaking against House Bill 5030.
Okay.
And the reasons are three reasons. Number one, the House bill would give the localities the opportunity to alter these war monuments. Many of these war monuments are historical works of art. And the idea of allowing the localities to tear them down and rip them up is against what we should be working towards. Secondly, removing the requirement to publish notice to the public, giving them time to have public input, and to not allow public input flies in the face of our democracy. So I urge you strongly to vote against this particular Bill 5030. Thank you.
Thank you for keeping your comments to the point. Andrew Moorhead. Mr. Moorhead. There you are. You got to unmute yourself. Unmute yourself. There you go.
Okay. Am I
Yeah, you're good.
Am I able to be heard?
Yeah.
Okay. Chairman Lewis and senators of the committee, I spoke to you all back in February on the slippery slope created by this. And as Senator Spruill has mentioned, this legislation pertains to all war memorials to veterans. In the House of Delegates, I commented on Delegate McQuinn's before I was so promptly shut down by the gentlewoman from Chicago, Illinois, that it appeared to me that the delegate's proposal would make it such that anyone with a car or a pickup truck could take these monuments down. And so what has happened? This legislation is about all war memorials to veterans. To make it Confederate specific is not such a good idea and would take a lot more time to digest. Furthermore, Delegate McQuinn basically got her way. I mean, I don't have any eloquent prose coming out of this past session, and I'm not sure why she wants to now strip every bit of any protection to anything. And so, having said that, there are so many things involved with this, and I just cannot implore you all anymore to vote against this. And if you can vote in favor of it and go home when the day is done and look a family member in the eye that is a veteran, or look a constituent in the eye that is a veteran of any war, and explain to yourself with a good conscience why you voted in favor of this, then God bless you.
Thank you, Mr. Moorhead. Ron Moore. Is Ron Moore on the line?
I don't believe he is.
Okay.
He is on by phone.
Yes, I'm here. Can you all hear me?
Yes, go ahead. You're on.
Okay, Senator Lewis, thank you. And dear Senator Lewis, Chairman, the State and Local Government Committee, I'll just address a few issues and try to be as brief as possible. I have the honor of working with Senator Reeves and Delegate Walker that were conferees on HB 1537, the current law regarding some of the key issues that ultimately were signed into law by the governor. And I want to review a few of those today. Those compromises were pretty significant. One of them was alteration. Professionally, I'm a professional fine artist, graduated from Virginia Commonwealth University. I'm very familiar with clients. I've been commissioned. I understand what an original work of art is. So some of these are very important. Alteration has been added back in, public notice removed, future disposition removed, VMI's exception repealed. Alteration, ultimately, you're talking about the state-sponsored obliteration of original works of art. So the question would be, is it right for the state, the Commonwealth, or a locality to actually encourage, endorse, and condone the ability for either to obliterate a piece of artwork? Would we venture into the Virginia Museum of Fine Arts, the National in DC, Smithsonian, or the Louvre, or anywhere else, and dare consider scribbling our personal, political, ideological, religious, or other opinions on an original work of art? I don't think it would be hard for us to say no to that. I'll speak briefly about rumors of war as an analogy because it relates to what alteration ultimately means, and to McQuinn's point in light of the current circumstances in the Richmond and, for instance, Portsmouth, etc. Rumors of war is a prime example of the fallacy of altering these monuments. And by the way, I'm not a fan of this sculpture, but I understand a patron, and I understand the intent, and I understand the fact that it's a legitimate piece of artwork. Inscribed on the pedestal are the words, rumors of war. This statue that is titled Rumors of War is a satire and modern commentary of the Jeb Stuart statue. We all know that. In fact, it's intentionally a copy of that statue created as a parody. Removal of the pedestal from that statue would destroy the original work of art as created by an artist. Rumors of War demonstrates that the pedestal and the statue constitutes one piece of artwork. Regardless of the current situation in Richmond, the alteration of those statues and the removal of them from the pedestals would contradict a civilized society and the higher achievements of mankind. It would also potentially, which has been suggested, legitimize vulgar profanities as spray painted on these original works that are under the care of the Commonwealth and localities. I hope that you will not consider doing that. Public notice. Despite the zeal of Richmond and Charlottesville, and this was mentioned in the original public hearing meetings that I attended, some localities have not had adequate time to engage the public over these memorials. They just haven't. Notice to the public and public participation should be expected of a government accountable to the people. Future disposition. This has been touched on by you guys today. Only parties that are interested in the preservation of these massive original works should have the opportunity to take possession of them. In case, specifically in Richmond, that a city has officially received a proposal to piecemeal chop up the Stonewall Jackson Monument. Again, should the Commonwealth condone and support the ultimate destruction of original works of art? Let's talk about VMI, and I'm going to be closing in a couple seconds. Thank you for your patience. The military history of VMI is a valuable and indispensable part of VMI. I think you all know that. VMI statues of Stonewall Jackson and Virginia Mourning are at risk in this legislation. The artist and sculptor that created them was a VMI cadet, VMI Newmarket veteran of the Civil War, and an internationally recognized artist. His name is Ezekiel Moses, who is Jewish. I encourage y'all to consider what alteration would really mean for the state. I understand that you can relocate them and remove them, but all of those pedestals, just like the Rumors of War, are inscribed, and they're directly designed with those statues. As a professional artist, I encourage you to reconsider alteration, and I appreciate your time today for letting me speak. Thank you.
Next in queue is Robert Lamb. Mr. Lamb, are you on?
Yes, sir, I'm on. Can you hear me?
Yes, sir, we've got you.
All right. Thank you for allowing me to testify. I worked very hard with a number of the members of this committee during the regular session, particularly on due process concerns that were of great concern to, among others, the chairman of the committee. And the bill in front of you would eviscerate all those due process concerns. The hearing, the notice, questions of where the ultimate disposition of these monuments and memorials might be. And it also removed the protection of monuments in public cemeteries, of all things. All those are just off the wall as far as I'm concerned, and improper. I think the idea that it would somehow give more flexibility to the local government is kind of nonsense, because it really would allow them the power to do most anything they wanted to do without any kind of requirement from the public. Lastly, I'd like to speak briefly to the question of Article 4, Section 14 of the Constitution of Virginia, because that, I believe, is a restriction. That whole section, Article 4 relates to limitations on the legislature. And the courts have right now within their breast jurisdiction of the case involving Massey versus Stoney. So I think that the Virginia Constitution itself, in paragraph 2 of Article 4, Section 14, is a precise limitation on the type of legislation the Delegate McQuinn is proposing now. So my suggestion is that it's not only improper, this bill should not be reported out of committee, period. Thank you for your time.
Thank you, Mr. Lamb. Next up, Dylan Bishop. Is Dylan Bishop in queue?
Yes, sir, Mr. Chairman. Can you hear me?
Oh, yeah, there you are. Go right ahead. Yes, sir.
Mr. Chairman and members of the committee, thank you very much for your time. I'm here to speak on behalf of the Virginia History and Heritage Coalition, which is an advocacy group for the preservation of Virginia's historical landmarks and monuments. You may recall that VHHC worked with this very committee during the 2020 General Assembly session to amend House Bill 1537 to include important due process safeguards in that bill, which is ultimately enacted by the General Assembly. And I'd like to echo the chairman's concerns about process as it relates to the constraints of the special session generally. The call of the governor did postulate that the General Assembly could deal with operations of local government, but only insofar as they relate to the COVID-19 pandemic. So I think this piece of legislation is somewhat outside of the bounds of the call of the governor in the special session. Also, House Bill 5030 would eviscerate the right to public notice and a public hearing, among other due process considerations. It eliminates the requirement to offer a monument to a memorial or a museum or a historical society, which I think is a gross oversight. And then finally, this has been touched on a number of times. Like the previous speaker mentioned, Article 4, Section 14 of the Constitution of Virginia expressly prohibits the General Assembly from enacting legislation or granting relief in cases which are pending and subject to the jurisdiction of the court. So for all these reasons, I would ask the committee not to report House Bill 5030, both as a matter of policy and a matter of constitutional law. So thank you for your time.
Thank you, Mr. Bishop. Final speaker is Volpe Boykin.
Yes, sir, Mr. Chairman. Can you hear me?
Yes, we've got you. Go ahead.
Yes, sir. I'm in opposition to the bill, and I won't belabor and repeat what others have already stated. I agree with all those statements, so I'll just leave that there. A couple of things that I am concerned about is one, the no public notice. Virginia should be transparent. Virginia should give as much public input as possible on any issue, especially an issue in a state with so many veterans that are concerned about all war memorials. Taking away that transparency, taking away public notice is just simply wrong and un-Virginian. We should be an open state to the citizens for citizen input. I just don't know how to say how wrong I think taking away public notice is. The other, on the safety issue of threats dictating what any locality or the Commonwealth does with any piece of property or building or anything else. I ask, when does it stop? If there's a piece of property, someone says, I'm going to vandalize if you don't do X with it, does the legislature or the locality give in? If there is a building that maybe someone doesn't like because of what it stands for some reason, and a group of people says, well, we're going to destroy it or burn it down if you don't get rid of it. Basically, my question is, where does this stop? I don't think that the Commonwealth or any locality should ever give in to lawlessness for any reason, because giving in to some lawlessness creates more lawlessness, which creates an entire lawless society. So that should be stopped no matter what. And sometimes that's hard, and sometimes sacrifice, I know, because I'm a retired police officer, is involved, but that's what the law is. If the law means nothing and you conform to lawlessness, that is what you have, is lawlessness. The last issue I want to hit on is alteration. One point nobody else has spoken about is the fact that some localities, and I have seen proposals, one in particular, could alter these monuments into perpetual insults to part of Virginia's population. And whether you agree with that population or not, creating perpetual insults to anybody or any history or Virginia history, whether it be Revolutionary War or some other war, it creates bad feelings that would be long lasting bad feelings and division for people to be looking at a perpetual insult. Again, I won't repeat what everyone else has said. I appreciate your indulgence with me. I appreciate the committee's hard work, but I would ask you to not pass this bill out of committee. And I thank you very much.
Thank you, Mr. Boykin. All right, that's all the public comment that we have. Senator, Delegate McQuinn, let me ask you this. I have no idea. I'm looking at the names up here. I'm trying to figure out where we're headed with this thing, but I can't. I'm not quick enough in my head to figure that out. And I know you and I think briefly touched on this earlier today.
Mm-hmm.
I mean, this bill, if it passes, won't go into effect until what, January 1 or thereabouts. We're back in session January 15th. We can't carry over to the next session, unfortunately, procedurally. Would you, and by the way, just a full disclosure here, I got a text while we're on here. The Virginia Press Association is concerned and opposed to the bill because of the lack of the notice requirement, the lack of public hearing piece of it, if it goes forward as introduced. So let me just say this. Would you consider, how would you feel about, I mean, we could ask the Department of Historic Resources to take a look at this between now and the next General Assembly session. The bill would only go into effect, I guess, 2 weeks before we go into session anyway. I leave that up to you. I'm just throwing it out there for you and for the committee's consideration.
Mr. Chair, thank you so much. I would be, if that's what you all deem appropriate, that's fine. I just, again, and I want with all of the conversations and those who have, from the public who have spoke, I want to know that the cemetery issue was taken out, so that is not an issue now. And I also just want to clarify that it's basically saying to localities that you have been elected. The expectation is that you would be transparent, that you would do what is appropriate to address those things that affect you the most. And so say that it was taken away because it's not stated. I don't see that, because there are local laws and regulations as well in terms of how they handle various things. And so again, it gives the locality authority to establish their own process. And this has never been put in place. When I look at with the statues, again, if we go back to the purpose of them being erected, then to say that this is not something we ought to be addressing now is extremely interesting. But this is a different time, and I know, and those who have looked at it know, that these statues and monuments has never been intended to represent all of the people. And we must, again, look at it, address it, and if the localities feel the desire to either leave it up or take it down, I just think that the law, those kind of things are closest to the people. And my thought was to give that authority to the people.
Mr. Chairman.
Wait a minute, let me clarify something, Senator. Dave, Delegate McQuinn, is the cemetery piece is still in there, right?
No, that's taken out. You mean in terms of the cemetery piece is there, but not for private cemeteries.
Okay.
Yes, right.
Okay.
Mr. Chairman, if in fact we're worried about a lawsuit, I think this entire bill could arguably be outside of our tradition. But I will just say, I mean, one way we could have helped this is in my amendment, although I remove the obligation for a public hearing, we do not explicitly state that the locality must come up with some process for determining the removal. And I would be, if I could amend my amendment, I think that might get us a little closer to where we want to go if it's the wish of the committee. Because nowhere here does it say that the local government has to come up with a process. It just removes the public hearing requirement. But local governments can come up with an administrative process. Local governments can come up with options that don't require a public hearing before the Board of Supervisors, but still there's a public process. And that is not required at all in this bill. So there is a middle ground. I guess the question is whether, may I offer a second middle ground? And if that goes down, then I think the bill's probably going to the Historic Preservation Committee.
Mr. Chairman?
Senator Howe.
May I offer my, okay.
Also, well, I was going to suggest that I think we need staff and others and some attorneys to think this through. And I think the appropriate thing for us to do would be to report the bill and expect there to be floor amendments.
I understand what you're saying, but I think it's best to try and get as tidy as possible in committee.
Mr. Chairman, may I offer my amendment to?
Sure you can.
And
I'll second that.
I did not work through, and I would ask David May to just, I'm not David May, David Barry to just correct me. So on line 41 of my substitute that failed, I would put a period after initiating or completing the provisions of subsection B. I would put a period. However, and we can correct this on the floor, the intent would be, however, locality must establish some public process for removal, relocation, or altering any monument.
Can I ask you, what do you envision that being other than a public hearing?
Well, the county manager can take comments. You can take written comments. You can set up in your administrative code. You can create notifications to surrounding neighbors. Once that notification is completed, you can issue a decision. You can have the zoning administrator issue a decision. So there are options. And I apologize, I didn't have enough time to really talk about that, but local governments can come up with public notices and a public process that don't involve a public hearing, but still bring in a lot of people. Again, a lawyer would have to really work on that, and I would be willing to offer that as.
And again, I mean, I think that highlights, and Senator Howe's comments highlight the limitations that we have in this special session on anything of any complexity.
Okay, may I amend my motion to say, if this goes to the Historic Commission, that there be a letter from this committee with some articulation on the need to exempt localities from a full-fledged public hearing, and then, however, the need of providing some kind of public input.
Well, and I would expand on that. I would think if we chose to go that route, that we also, perhaps if we can, involve the Attorney General's office with some suggestions on how we might, in situations of imminent public safety threat or something of that nature, how we might come
exempt
up with a way. Right. But I just don't think it's the forum to do that. But anyway.
Mr. Chairman. Mr. Chairman, in the past, on commercial labor, we have seen that we have bills now that people are trying to get input. And we have, in commercial labor, in the past, we have taken that bill because of the shortness of the time and because of our lawyers who have not properly vetted the bill the way they should. we have known that we only have one shot at it. We have sent that bill to the floor, not no recommendation from either side, but sent the bill to the floor to allow us, members who are committed, to allow our lawyers and others who have input and pass it out of the floor. We have sent bills on complex labor, and also I want to say P&E. We have sent bills to the floor with no recommendation because of the shortness of the time and the recommendation that everybody's trying to cram it in there to get us to vote for something. But because of that, that would give our lawyers time to look at it more. That would give people on the committee time to look at it more, and others. We have sent bills to the floor, to the full committee, without a recommendation to give us time to see what we can do with it and turn it down, pass it or turn it down at that level. So my question is this: why cannot we do the same with this to give us time, our lawyers, you, the committee, and everybody time to look at it on the floor? Why can't we send this to the floor without a recommendation and resolve it there?
Well, I think the only problem with that is the rest of the senators who aren't on local government would kill us because we're supposed to sort of send it out in a somewhat final format, and that's what we're here for. And if we try to write legislation on the floor, which you're right, we have certainly done in the past, that is not a recipe for success, I'm afraid. So,
Mr. Chairman, this is Emmett.
Yeah, Senator Hanger.
Thank you. Thank you. Listening to the conversation here, and all due respect to the patron who I admire and worked with in the past and hope to work with in the future, I really believe the direction for us to go today for that extra time is for it to be passed by for the day, that you in your wisdom draft a letter requesting the Historical Society, the Attorney General, whoever might be, have some input into the merits of the bill, to work on it before January. As I make that statement, I want people to recognize that when the prototype for this bill came out of conference back in regular session, I looked at it very closely because my side of the aisle didn't like it. And then there were a couple of us that said, they've fixed this adequately, and I voted for it. And in hindsight, I'm glad that I did. But I'm certainly not prepared now, particularly with litigation ongoing and where we're at with this lack of understanding of its implications, prepared to support it today. So I move that we pass the bill by today with the instruction to the chair for a letter.
Second.
All right, we have a motion to second. Let me make a procedural inquiry to Legislative Services. Can we pass by and do a chairman's letter?
There are, Mr. Chair.
Yeah, Toby.
There's pass by indefinitely with a letter. Is the only motion we have with a letter, but you're more than welcome to pass it by for the day, and you as chair write a letter. But in order for the letter to come from the clerk, the motion would be passed by indefinitely with letter.
You can't do that, Mr. Chairman. You can't do that. If you pass by for the day, that means that we can look at this thing again without a letter. That's what it's saying. The Emmett said, I'm sorry, I apologize. Something Hanger said, pass by for the day. So pass by for the day, then that give us time to look at it again.
But I don't
so I'm in agreement with passing by for the day. That give us a time for you to call us together again to look at it. So I think I'm in agreement with that. Pass it by for the day. Give us a chance to have another meeting to look at it again.
But full disclosure, Senator Spruill, I don't think we want to have another meeting of local government.
Wow, I love y'all.
I think that was Senator Hanger's point for the letter, and give us time until we reconvene in January.
Mr. Chairman, Mr. Chairman, if you just allow me, I didn't realize until late yesterday that there was even a problem. So there are many things that are arising now in terms of this bill that again, I didn't realize that there were some challenges with it. And I wish that those who have concerns would certainly have shared it with me a lot earlier about there being some problems and concerns that you had. I would have loved for this bill to pass out and that it would have gotten to the floor. And if we had some time then to try to work on some of the logistical things. However, I know there's a motion on the floor that has been seconded. It is with the intent, please know what my intents were. And it still remains that I think that we are in a position to do something to help the present day situation, and not to do something, to me, in many ways, is somewhat of a failure on our part. Thank you. I think Mr. Marshall keep raising his hands, but he had mute on, I think.
Let me say something really quickly, and then I'll come back to Senator Morrissey. But I appreciate everything you've done. I understand your advocacy. I understand your concerns, and they are well placed. But I think, again, as you pointed out, you didn't realize till yesterday it had problems. It just highlights the difficulty we're having with a lot of this stuff under these circumstances. And so I think if this motion should pass, you certainly live to fight another day. And have those arguments still intact. Senator Morrissey.
Thank you, Mr. Chairman. I too want to commend the delegate for bringing this bill before us. In the last several minutes, there have been discussions regarding amending this bill, fixing it, tweaking it, whatever. I just want to bring to Delegate McQuinn's attention that one of her colleagues in the House who very much supports this bill brought up a possibility of a substitute, which, for example, took out the VMI exception. The only reason I'm bringing that up is not to create more troubles, but just to, there is some movement, Delegate McQuinn, Mr. Chair, to do some maneuvering with this bill without doing it any harm. So with that said, I always like to know what the patron wants to do when there's a motion to pass by the bill indefinitely, which I understand, Mr. Chairman, that is the motion.
It doesn't, no, sir. It's said for the day. It does not say indefinite.
Senator Spruill, I got hit on the head a few months ago.
I apologize.
I'm not as quick as you are. Is that the motion to pass it by for the day?
That is correct. Yes, sir. With a letter.
Okay. I'd still want to know Delegate McQuinn's feeling on passing by the bill for the day.
I would not, because I know basically that does not help the bill.
Okay. Thank you, Mr. Chair.
All right, we've got a motion properly seconded. I believe this is a voice vote. Is that correct?
Mr. Chairman,
Senator
Donovan, was there not a substitute motion that was seconded?
No.
I thought that's what Senator Hanger did. I'm sorry. What did I second?
That is the motion.
That is the
motion. The motion is to PBI with a letter.
Yeah. Yep, pass by for the day.
Pass by for the day.
Mr. Chairman. My mistake.
Senator Howe.
With some trepidation, I have a substitute motion.
What is that?
The bill be reported.
Second.
Okay. So that's a recorded vote, I believe.
Yes, sir.
I'd like to call the previous question.
Senator DeStefano is trying to call the previous question. Anybody want to play Twister?
He's trying to keep them voting. That's what his problem is.
Mr. Chairman, what's the priority? The latest motion to report, does that take precedence over the motion to pass it by for the day?
I'm going to have to look for guidance on that, but I think it does.
It passes.
Mr. Chair, the motion for we would call the roll for the motion of the previous question. If that is successful, then you would go to the pass by for the day. Does that make sense?
All right, but
I think you just said roll call on.
Everybody back on. Does his motion take precedent?
There is no precedent. We don't have any precedent. The motion before us is the previous question.
Okay. All right, call the roll then.
Could I ask? Oh, shit. Oh, no.
Good.
You're there, Janet. You there?
No, I'm not. I've lost you all.
No, I see you.
Oh, okay. Well, I don't see you anymore. I asked just a parliamentary inquiry. If you want to report the bill, how do you vote on this previous question?
Vote your conscience.
No, I mean a yes or a no vote.
Mr. Chair, if the previous question is if there are more yays than nays, then we would go to the motion to pass by for the day.
Okay. All right, let's call the roll.
Mr. Chair, just a point of clarification. Are we voting to report or are we voting on the pass
Previous
by?
question. Voting on the previous, call the previous question.
That is what?
I think the previous question is lost.
It goes back to the original motion, which is passed by for the day with the letter.
No, go back to substitute.
Well, sir, no, it doesn't. We got to vote. Okay.
Okay.
All right, call the roll.
Senator Hanger.
Yes.
Senator Stanley. Senator Favola. Senator Favola, I think you're muted.
That was the motion on the previous question?
Yes.
I voted no. I mean,
Yes.
Yes.
This is a process vote, is it not?
Come on, Bob.
I want to keep talking, so that
Muted yourself, Barbara.
She voted no.
if I wanted
Mr. Chairman,
to keep talking, I
Mr.
would
Chairman.
vote no.
All right, everybody. Let's
I know you.
Hey, whoa, everybody. We're in the middle of a vote. Barbara, are you yes or no?
I am a no, Mr. Chairman.
All right, keep going.
Senator DeSteph.
Yes.
Senator Donovan.
Yes.
Senator Chase.
Yes.
Senator McPike.
Yes.
Senator Spruill.
No.
Senator Howe. I'm sorry, Senator Howe.
No.
Thank you. Senator Morrissey.
No.
Senator Pillion.
Yes.
Senator Bell.
I vote no, and so do my dogs.
Senator Hashmi.
Yes.
Senator Kiggins.
Yes.
Senator Lewis.
Yes.
9 ayes, 5 nays.
All right, so the motion in front of us is Senator Hanger's original motion to pass by for the day with the chairman's letter to Historic Resources and the Attorney General.
Mr. Chairman.
Yeah, Senator McPike.
Thank you, Mr. Chairman. If I could just speak to the motion. I appreciate the delegates' work on the bill and the issue at hand. I would just like to comment on any legislation that does not afford public comment. I would be strongly hesitant about. That's one of our principles of democracy, whether we like something or we're pro or con something. And, certainly, open to ideas on a number of days or different provisions, but I do think public hearing and public comment is fundamental. And I do know the delegate pointed out to localities having different options. My concern is there are rules in local government that also allow folks to bring something up on the floor for a motion. And so, that's my caution in the bill is degrading the ability of public hearing on it, the underlying concept. And I think the urgency of trying to figure out a process, maybe it's less than 30 days. I'm not sure, but I just wanted to make sure that I was able to communicate that with the delegate. I think where she's getting at, I'm not sure we have all the mechanisms quite there yet with the bill before us.
I think a lot of us share those same concerns, Senator McPike. All right, the motion before us is Senator Hanger's motion. There was a second, and I believe it's a voice vote. Is that correct, Hobie?
Sir, I apologize. For clarification, is the motion to pass by indefinitely with a letter or just to pass by for the day?
Pass by for the day.
Okay. Pass by for the day can be a voice vote.
All right, all those in favor of Senator Hanger's motion to pass by for the day with the understanding that the chair will do a letter to the Attorney General's Office, Department of Historic Resources, say aye.
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 Opposed?
No.
Ayes have it. All right, is there any other business to come before the committee?
Mr. Chairman, may I? I don't have any any other business, but I do want to thank the committee for your indulgence and and for the very lively discussion on this particular bill. I appreciate it, and I appreciate those who are trying to find a way to move it forward. Again, you know what, this is it's a process, and I thank you again for your input. Thank you.
Thank you, Delegate McQuinn. Thank you for your work on this bill. Thank you, everybody.
Chairman,
Senator DeStep?
before we adjourn, I just wanted to let the record reflect that I believe since excuse me?
Go ahead. I didn't say anything.
I wanted the record to reflect, since we're meeting in person, that I believe that this meeting should have been met in person as well. And according to the AG's letter, that I believe that we have the ability to meet in person, and we should. Thank you.
All right, understood. All right, everybody. Committee's adjourned. Thank you.
Have a good day. Thank you. Thank you.
Thank you.
Thank you, Doris.